Good morning and welcome to Review Commercial Contracts. Remember, if you know someone who deserves to be recognized for their hard work, be sure to nominate them for our 2020 awards show. Categories are Realtor Managing Broker, Realtor Office Manager, Realtor Volunteer of the Year, Young Professional of the Year, Affiliate of the Year, and Realtor of the Year. The deadline to nominate is tomorrow, Wednesday, September the 30th at 5 p.m. For more information or to nominate, please go to www.nsdcar.com. And now, Fred Pfister.
Good morning, everyone. It's nice that we're all here on this webinar. We're now in the 6th month of quarantine, so we're still doing these webinars, but these are great, and I actually hope that this continues because I think it's a great way to reach out to everyone. As you can see today, our focus is going to be on commercial contracts, which is an interesting topic and certainly a topic that North County is expanding on. Today, you're not only going to hear from me, but you're going to hear from another attorney in my office, Anna Burnett. And we're going to be talking about the two major issues that we see with commercial contracts, which are the purchase agreement and leases. As broad a topic as that is, we're going to try to narrow that down, and I'll show you exactly what we're going to talk about. But first, the shameless plug. My shameless plug here is, here's my headshot and a little bit about my experience. As you can see, I do work in the field of commercial leases and commercial purchase and sale transactions as part of my practice. I've been the general counsel for North San Diego County Association of Realtors since 2016. And a lot of my focus, especially in the last couple of months, has been on commercial lease transactions, a lot of workouts. And we'll be talking a little bit about that today, how it really applies, because we're seeing, a major upheaval in the commercial leasing world, more than almost any other sector through this pandemic. But I also focus on, of course, transactional work, multifamily, retail, industrial, and of course, land deals up here in North County. In addition, you're going to be hearing from Anna Burnett in the second half of this presentation. She is an attorney with our office, and she also does real estate transactions, commercial real estate transactions. She does entity formation, which is, of course, near and dear to a lot of your clients' heart when they're buying and selling real estate, title review, transaction coordination, 1031 exchanges, a lot of the work that goes into helping you serve your clients, because that's really a lot of what the focus is going to be today. Is going to be, we're going to talk about things that we see in transactions that are important to your clients. Good. That's our major focus for us. And then, of course, we'll open it up to questions at the end. These webinars tend to go a little long, but we're always available also for follow-up by phone or email, and we'll provide that information, of course, at the end, but I'm sure you can all look it up too. So let's go into what we're going to talk about today. Today, I have 4 topics for you. The nuts and bolts of commercial leases. This is going to be somewhat basic, and I know a lot of you are quite sophisticated at commercial leases, but we're going to go over some of the basics just to get everyone's feet wet on this and what we see as the fundamental parts of a lease. Then I'm going to talk about lease problems and deal breakers, and the specific focus is on reasons why a deal doesn't get done or problems that we're seeing. Not necessarily litigation or anything like that, but disputes, things that hold up transactions from getting them closed. And the point is to address those up front and to work together on those so that those problems don't become deal breakers. Then Anna's going to shift to some things that probably you're hearing for all your clients, and certainly on the landlord side, but on the tenant side too. This is the force majeure, impracticability, frustration of purposes, these defenses in commercial leases, because I get a call every week regarding, can I use this defense? And so Anna's going to go over that in some detail. And then we're going to finally finish with purchase and sale agreements and issues that we're seeing there. So without further ado on this, let me just go into the nuts and bolts of commercial leases. There's three general types of leases that you're seeing or that you're drafting and or negotiating. And it really depends on the type of property and the sophistication of the sides and you know, and really the size of the landlord or the tenant. Of course, you see the gross lease, which is, you know, probably the most basic, which is you just pay a flat fee for the monthly expenses and to rent the property, and that's it. Those are what we obviously see for the less sophisticated leases, the smaller value leases. When you get to the triple net, which is a lot of the ones that you're doing now, is the tenant pays for essentially everything until they don't. And I'll talk about a little bit of that, because that often does come into play, that sometimes people think of the triple net as it pays for every little thing, but there's often some exclusions. And so we'll talk about how those can trip up people. And then of course the modified gross, which is kind of the hybrid between the two, which is, you know, there's generally a flat fee, but there are some share of property expenses that are paid by the tenant. So here's what that looks like on a dollar figure as an example. You know, this is something I'm sure that many of you are familiar with, but this is somewhat of a refresher that the triple net, we're talking about utilities, we're talking about common area maintenance charges or CAMs, sometimes called operating expenses. We're talking about the base rent and property taxes. The modified gross is typically, it's typically a base rent with utilities on top of that. And then the gross is just you know, this is what it is per square foot. And we see all types. I mean, I've seen, you know, properties that you would imagine would be triple net or gross, and properties on the other side where it's a very small operation, but they're doing triple net. So, you know, obviously most of your landlord clients want the triple net. Most of your tenant clients, especially the smaller ones, would prefer the gross because they don't have that. It can't change dramatically over the course of the lease, because that ends up hurting a lot of people. And I'm going to talk about that a little bit in the context of property taxes, which is a major one right now. But let's do a couple more basics on this. The basics, you know, I mean, this is lease 101, but we certainly have to take into account what are the premises. It's surprising to me that I get transactions where still people haven't really defined the premises. They get into an LOI, they get halfway through the lease, and then I hear that, oh, I thought we did get the patio, or I thought it was this square footage when it really wasn't. So one of the things that obviously is very basic is defining what the premises are. What are we leasing? Of course, what's the term? And when does that term start? And we'll talk about that, how that has become, at least in the last several months, and even before that, is a major deal point and a major point of dispute and a deal breaker in a lot of cases. Of course, the rent, the security deposit, operating expenses, those are always important. What you're going to use the premises for, and allowing, we'll talk about exclusivity and those issues, but what's the use of the premises going to be? I see a lot more. I see a lot of landlords being very much more specific than they used to be on that issue. They're really defining that in the LOI or even in the lease agreement, where they're defining a very specific use and not allowing a change, which obviously you can imagine is to the benefit of the landlord, not necessarily the tenant. And then, of course, the alterations to the premises and tenant improvements, another issue that really needs to be laid out from the beginning, because it's often critical to the actual opening the property. So another thing that's fundamental, and again near and dear to your heart, is, because I'm sure you're doing this almost every day, is the letter of intent for leases. Where I'm seeing is the letter of intent goes out and the parties sign it, but they're not necessarily spending enough time on it, and especially on the tenant side, not not really securing what's their needs, if you will, making sure that they have things that they absolutely need in that LOI, because often after that point, it gets into the attorney's hands or it gets into heavy negotiation. And if the needs aren't up front, we're seeing problems there. Obviously, you have to agree on the LOI. The attorney's not typically involved in that case. The attorney often comes afterwards. Because I see it as this: you identify the needs for a tenant. If you're doing the tenant side, at least, you identify their needs. You view acceptable properties. You send out LOIs, and hopefully you're sending out multiple LOIs, because that's where the leverage I see. I see a lot of people getting involved in they sent out one LOI and they're putting kind of all their eggs in that one basket. And then if it doesn't work out on the ultimate lease, they're starting from scratch again, which is difficult and time consuming. But then if the LOI is accepted, that's where I see counsel getting involved in these cases and meeting the attorneys. But the key is for them to really work together. And then once that lease is thrown out there, it really should be a working relationship between the broker and the attorney to really get that deal done. I would tend to, what you really want to look for is you want to look for deal makers when you're looking for that attorney. If your client doesn't already have an attorney, oftentimes they will, but if they don't have an attorney, especially on the tenant side, you look for deal making attorneys. This is my shameless plug, is we look to make deals on these, don't break deals, because anyone can break a deal, but it's focusing on what's really important. And certainly on the landlord side, it's focusing on solutions. If there are problems, look for solutions, but don't minimize the issues. This is general advice, but don't minimize issues. If you have a must-have, like you have to have an exclusive because there's somebody else in the shopping center that has an exclusive, don't wait, till the transaction's halfway through to bring that up or to say that is really important. Put that in the beginning. It's going to go a long way. And on the tenant side, the issue is to realize your leverage. I mean, if you're taking up 5% of a shopping center, you don't have a whole lot of leverage there. If you're taking up 50% of the shopping center or something like that, you have a whole lot more. And this will, this should be very important to you, but I tend to tell the tenant side, because often, as you can see in the slide, the tenant provides the lease about 99% of the time. The limited exceptions are things like big box retail, or something like that, where they have a lot of leverage. But focus on the financial issues. Don't look at the doomsday scenarios. And I'm talking to brokers right now, so I know that you're generally focused on the business financial issues, and sometimes it's the attorneys who are focusing on the doomsday. But I would try to steer away from the doomsday scenario. So here's that half of 1% that could happen, that could ruin everything. But in exchange, somehow we're going to give up $1,000 a month. And, focus on the financial issues. The doomsday scenarios, while they're important, I'm not going to minimize them, but what really should be the focus is what have a material financial impact for the tenant. Tenant's not always going to get the best deal in these transactions. So at least on the doomsday scenario issues. So focus on the issues that are important financially. And of course, there's looking at this slide, there's different types of leases. There's what I see, of course, is something like the CAR or the AIR form. That I see those a lot, especially the AIR form. No offense to the association, but I see the AIR form more than the CAR. But we see a lot of them, but we see them with addendums because they're not one size fits all. I mean, they try to be, but we're seeing a lot of addendums. We're seeing a lot of custom addendums that people have ready for the transaction, and that's great. I consider some of those are broker drafted, some of those are attorney drafted, but it's really, really rare that I'm seeing someone just out of the box, oh, we're going to take the AIR commercial lease and we're just going to sign it without some modification. That is just not happening the way I see it. But maybe I'm not seeing every transaction, of course, because when we get involved, we're normally marking that up to the needs of the specific client. And again, On the broker side, you want to work with that attorney, and you should find an attorney who works with you with the goal of getting this space leased up. You know, don't over ask, but also protect your client, which is the ultimate, the ultimate goal of this. So let me go into, I talked of a few issues there, but this is where I want to focus a little bit more on the common lease problems and deal breakers. This is what we're seeing, that people are negotiating that are either killing the deal right up front, or it's becoming, it's heavily disputed, heavily marked up during the lease, or right after the lease is signed, we're seeing problems with it. And so this is something to talk to your clients about. This is something to talk to the attorney who's involved with, and it's something to even think about up front. I mean, it's something to think about even at that LOI stage, to be advising your clients as, okay, these are the things we should be thinking about. Because oftentimes I don't see the principal as focused on these things. They're interested in opening the business, right? They want to open that restaurant. They want to open that brewery. They want to, they're focused on their business. They're not focused on, things like, okay, how are we going to build these TIs? Or they want to know what they cost and what the design is going to look like. They're not as interested as, okay, how's the payment schedule going to go, or how much time I have. Sometimes those are front and center, but they're often not. So these are things that really you should be looking at as well as them. And you should also be talking to the counsel as well. So here are the ones I want to talk about today. Of course, we could have an even longer list. We could do 20 of these, because there are, each lease is different, and each property has something specific on it that can be a problem, from, access of the property to, remediation of the former use. But these are the ones that I'm seeing are the common lease problems and deal breakers. We're going to go over commencement. When does the lease start? When does rent start? Sometimes those are different. They often are. Work letters, those TIs that we love. Operating expenses and CAMs, how are those calculated? And what do those look like? ADA issues, those are still around. Those are still coming up in leases. Exclusivity of then securitization of leases and personal guarantees. Those are coming up, and especially now, I'm seeing lawsuits every week. People are getting sued because they haven't been paying rent, and they're getting sued on those personal guarantees. And so what those look like and what you're advising your client on there. And then, of course, change in control, things like assignments. So let's just jump right into this, because I know we have limited time today. In terms of commencement, you have really two different kinds. You have the soft, and you have the hard. The soft is fairly common, but this is for the wary. This is something that you really should be talking about, and it's come up more and more during this pandemic, which is the soft is where the commencement of rent or the commencement of the term is dependent on when the build out happens. Well, obviously, if you can't get permits, or if you can't get people to come to the property, or maybe you just want to delay for delay's sake, and commencement starts when those TIs are completed, people can delay that, many months. If you're on the landlord side, you're representing the landlord, and you wanted this restaurant to have been opened in May, it might still not be open, because there might not be availability of getting a permit, getting people on site to do the build out. Or maybe they're delaying it because they just don't want to open. And so they're saying that, that they can't do that. And without a hard cap on that, especially on the landlord side, that can be very difficult. And the problem is that a lot of this is negotiated up front on the LOI stage. And then people didn't realize this was going to be an issue. So when I'm on the landlord side, I counsel, okay, let's put a hard date. It's open for business, or it's dependent on TIs, but we got to put an outside date. If you're on the tenant side, of course, you don't want an outside date, right? You'd like it to be when it's ready. So this is something that you should be looking at if you're going to do a soft commencement date, of when does that occur and how does it occur? It also really depends on, oftentimes, especially with newer construction, you might have TIs for both the landlord or the tenant, or both at the same time. So make sure that that is all negotiated and negotiated early. It's a very difficult thing once you've signed the lease to try to renegotiate that, because there's too much money involved. Of course, you have hard commencement dates, which are more, we see those more with turnkey or when there's less TIs that are really needed. But those don't necessarily have to be. You can have hard commencement dates, like I said in the top there, for a hard date on the outside, that forces the tenant to move a little bit quicker. Those are important. And they're useful, certainly on the landlord side, for budgeting purposes. If they know they're going to be open by September 30th or October 1, whatever, it's very useful for budgeting. Of course, penalties, consider these. Talk to your clients about these type of things. What if the landlord can't deliver the premises? What if the former tenant, that, let's say there was a change in tenants and that tenant didn't leave? Does the tenant get a remedy, like they terminate? Do they delay? Those are important considerations that you should be thinking about before you agree to something like a hard commencement date. Work letters. Please don't overlook these. I'm seeing a lot of issues with this regarding the pandemic, because it's a quick source of disputes, because it happens right after the close. So you close a lease, and if one side or the other is not performing, you quickly can get into a dispute over why they're not performing. And what I often see with work letters, and why I call them deal breakers, is it's almost like an afterthought sometimes. We'll negotiate all the lease terms. I'll have an LOI, and I'll have everything going, and we'll be asking, what's the landlord's work going to look like? What's the tenant's work going to look like? And the tenant doesn't have it. They don't have bids. They don't have, they haven't really thought through. They have an idea in their head of what they're going to be doing, but they haven't actually put it down on paper. They haven't done a design, and they haven't engaged the architect. They haven't done their due diligence, and they're ready to sign this lease. And I see it sometimes slapped on to the back of the lease with something that's unrealistic. And so, my point isn't necessarily that the broker needs to do that work. That's not your role. But what it is I think what it is your role is to get your, when you're at that phase, the beginning of the phase, before you even throwing out LOIs, okay, do you have these people lined up? Do you have contractors lined up? Do you have an architect lined up? Do you have these people lined up to give you bids, to give you designs, so that when we get to okay, we've signed the LOI, we're ready to go. It's not a afterthought, because that's what I'm seeing, is it's being an afterthought, and there's almost immediate disputes sometimes over whether it's what that looks like, and why is it not proceeding the way it is? Because the landlords, or the more sophisticated landlords, keep a strict schedule. You look at some of these work letters; they're 10 pages long, and they have all these approval processes, and they have deadlines for things. And if you have an aggressive landlord, you're gonna you could certainly get into trouble quickly on some of these transactions. Of course, if you're on the landlord side, you want to be realistic too. Can you do let's say you have a landlord work letter, because these are the work letters, the tenant, the landlord, and sometimes both. But on the landlord side, does the tenant need to start their work before you can do your work? That's a key consideration. If you're agreeing to do something, make sure that it's not necessarily dependent on the tenant's work. That can be a key problem in a transaction like this. Other issues regarding work letters, I talked about this earlier, but specifying what the space looks like, what exactly you are going to be remodeling or improving. That's important. Make sure that there are diagrams. The costs, often in an LOI, it'll say tenant gets $100,000 or tenant gets $200,000, but it doesn't say how that's reimbursed, how that's paid. Sometimes it's a draw. Sometimes it's submitting invoices after you're already paid. Sometimes it's upfront. I mean, it really can vary, and it's a good idea to, if you're on the tenant side, to talk to your tenant and say, you know, do you have a plan to front the $200,000 that it's going to take to build this out? Or where's your line of credit on this? Or, you know, do you have the draw schedule of how we're going to pay these people? So it's important to look at that issue and not overlook that issue, because it can be a real source of problems immediately after that lease is signed, and people should look at it. Delays and consequences. What happens when there's a delay? Who's responsible for it? Of course, that can vary widely, but that's something that you should be thinking about and talking to the attorney about, and making sure that your client's buttoned up. They'll thank you for it. Another one is the approval process. This doesn't necessarily jump out at you, but if you're the tenant, you don't want to have every little thing approved, right? You don't want to have to, every time you do something, you have to submit it for a 2-day approval or a 4-day approval. You want to be able to work. And so negotiating that is important, and talking to your client about that is important. On the landlord side, of course, you want more approval. So it's really to what side you're on, and whether, and you know, how sophisticated the person you're leasing to. If you're leasing to, you know, a large retailer, a very sophisticated client, this is much less important. If you're doing a mom and pop restaurant, it can be incredibly important. And so it's really knowing who are you leasing to, and the sophistication. You can get a feel for that. I mean, we do all kinds over here. So I do everything from the mom and pop to to the large retailers. So I see the whole spectrum of, and I'm sure a lot of you do, the spectrum of, okay, from here's the the person who does it, who's drawing their thing on a napkin, and here's the ones who are coming in with 15 pages of how their sign's going to be rendered. You get all different kinds in this, especially here in North County. So let's take a look at. We're going to finish up here with just a couple more. Operating expenses. These are often you see in a triple net. But one of the things you want to look at with exclusions is that, just because it's a triple net, or just because the operating expenses or the CAM charges are thrown in there, there's often exclusions, even in what we consider triple net. And some of them are capital expenses, things like earthquake or other large expenses that are either uncommon or are one time. Often, the tenant will negotiate to exclude those. And this is an area where you probably always want counsel to negotiate this because you want to be as specific as possible. Sometimes overhead is excluded, sometimes it's included. Prop 15, this is important. I know a lot, near and dear to a lot of your hearts is the split roll that could be coming, where property taxes are for commercial properties are no longer going to be bound by Prop 13. And what would that mean to a property that's in, let's say, Encinitas, that's been owned for 40 years by the same family? Well, if that happens, it might get set to market. And what would that look like in terms of property taxes? It might go from the $300,000 that it says the property tax rule has to $3 million. Well, if you're if you're a tenant who's on paying for property taxes, you could have a massive jump. Are you prepared for that? Are you negotiating that ahead of time? Maybe you can't negotiate it if you're an existing lease, but you sure might be able to if you're leasing today. So, who knows whether that's going to come in, but that's something you really should be thinking about because that could be a shock to your clients, either trying to get protection, or if you're on the landlord side, no protection, right? You don't want to have them to have protection. Of course, if it's a more recent property, this is less important. But there's a lot of properties in North County. There's a lot of properties all over San Diego County that have been held by a family for 50 years or forever how long. They bought it in the 90s, whenever. And the property tax basis is fairly low. And so make sure that you're looking at that, that when you're looking at operating expenses. Of course, there's caps. we're seeing a lot of clients because of the change in things like property taxes and operating expenses. They're negotiating specific caps on whether they increases, or in the course on the landlord side, you don't want caps, right? You don't, your operating expenses are your operating expenses. You don't have always the control. A lot of times that's property management. That's things that you need. So there's always a give and take on caps. And then of course, here's the, on triple net, of course, the landlord wants to include everything, and the tenant, you want to exclude everything. So advise your clients that just because they're offering triple net, on the tenant side, if you're on the tenant side, just because it's a triple net doesn't mean you couldn't exclude certain items. And on the landlord side, make sure that you're including everything, get everything in there if they agree to triple net. That's a lot of give and take, a lot of attorneys arguing over those operating expenses, because let's be honest, those are material, right? Those are material financial considerations. And that's the type of thing that it's not necessarily a doomsday scenario. It can be real. And then of course, people are negotiating for audit rights. Seen a number of disputes, and this isn't necessarily a deal breaker, but I've seen disputes later on where people are saying, well, why did the operating expenses in the shopping center go up 20% this year? Well, if they had audit rights, they could figure it out. And so I see that as a not necessarily a deal breaker, but something that's certainly negotiated between the parties. Here are ADA issues. We're still seeing these mostly on older buildings, but it can crop up everywhere else. You have to have the CASP inspection disclosure. You have to disclose if there's no inspection certificate. I know that a lot of you obviously you use the form for this, but if there is no inspection, it's silent on who's responsible. So I tell people to watch out for this and make sure that their client, on the broker side at least, and, tell them to discuss this with counsel if the landlord, which they often will, are trying to push some ADA compliance on them. The law presumes that the owner's responsible, but obviously the lease can modify that. And so what we're seeing is landlords almost universally are trying to push that on to tenants, especially if we see triggers, like if there's common area changes, or those premises changes, or the TIs or remodels. They're often trying to make the tenant responsible. And so it's something to review with your client. They have all heard horror stories about ADA, but they don't always know what they have to do and where it would come up. So keep in mind the ADA issues. Exclusivity, we're seeing a lot of this. Make sure to work this out up front. This is especially important in shopping centers, obviously, where there's exclusivity of one type of use versus another. When I mean work this up front, don't get all the way down the line on the lease, and then you realize that you can't put this, you can't put another pizza place in here, but that's what you primarily sell. So it's important to get copies of the other exclusives as early as you can, so that you can work this out. And of course, negotiate heavily if it for the tenant, if it's limiting. This is something that should and can be negotiated. And when I say renegotiate on landlord side, that you see that item, is that we're seeing this being negotiated a lot with workouts or abatement of rent in the last couple of months, where landlords have given a break to certain uses in their shopping centers or in their shared spaces, and what they're doing is they're conditioning it. They're conditioning that abatement or that rent deferment on a change of exclusive, or getting rid of that exclusive. So it's something that you want to look at if you're helping a client through that process, or even up front, you're making sure that all the exclusives in this particular shopping center are up to date. Two more on the topic of leases. Certainly, securitizing a lease, we're seeing what's considered by the landlord. Certainly, the credit worthiness of the tenant, but also who's actually signing the lease. It seems kind of strange, but oftentimes this is being glossed over that, oh, we'll be setting up a new entity that hasn't been created yet, because oftentimes people, even if they're moving their business into a property, they sometimes have other entities, sometimes management companies for multiple businesses. So who's actually signing the lease? Is it the guarantors? Are they signing personally? Is it just the business, which may or may not have any assets? So it's important to figure out what the creditworthiness of the parties are involved if you're on the landlord side, so that you know who to include on this lease from the beginning. Obviously other things that are considered by the landlord are the vacancy and transactional costs. What are all these costs going to be to get into this lease? Do we want to ask for, for instance, a higher deposit? Do we want to, we're going to have a lot of transactional costs just to enter into this lease. I mean, we're going to have, the commissions, the attorney's fees, the TIs. So you really want to emphasize that up front, so that you're not getting a tenant who's not going to be able to perform, because, otherwise those are going to be a lot of sunk costs. I've seen a number of clients get burned on that, where they've sunk in, significant costs into a lease from a tenant that probably they never should have leased to in the first place, because they failed right away, or they walked away at the ninth, in the bottom of the ninth of a lease negotiation, when, the red flags were there from the beginning, for instance. So here's the methods of securitization we're seeing. Of course, a letter of credit, especially with high TIs. Personal guarantees, of course, everyone knows those, and security deposits. Personal guarantees, I'm seeing multiple personal guarantees often. Make that a consideration when you're on the landlord side. And of course, if you're on the tenant side, look at burn-offs. I'm seeing a lot of that. I'm seeing a lot of people ask for that, which is essentially, after a certain number of years, after a certain amount of the lease you performed, a number of years, or you're getting into the option years, they're asking for burn-offs, that we're not going to personally guarantee this anymore, or that large security deposit is going to burn off. So, if you don't ask for it, you don't get it, is the way I always tell people. So, but I'm seeing that more and more, that people are asking for that, so that they can have a little bit more security the later they are in the lease on the tenant side. Of course, if you're a landlord, you don't necessarily want that, but maybe you do after 10 years. It's a really good tenant then. Last thing on leases is change in control. Of course, the assignment of leases, a lot of leases prohibit that, and a landlord oftentimes, wants strict approval. But the tenants, you want some flexibility. So don't necessarily give that up if it's a smaller location, or I would say negotiate so that you have some flexibility. It's not a strict yes or no. It's, reasonableness standard, or it's, something where it's a related party, or if it's the same type of business, or if the person will give a personal guarantee along with an assignment. So, if I were on the tenant side, I seek some flexibility. There are some landlords who won't even, offer flexibility, but I see a lot of them do. A lot of them, as long as they have some reasonable approval process. So that's important. I'm seeing that's important now. Certainly subletting is important now, because a lot of businesses are failing on the commercial side, and they would love, I get calls all the time, or this summer saying, I'd like to sublet, but my lease says I can't, or I'd like to try to sell my business, but, the landlord can approve this. I didn't negotiate that up front. They weren't thinking about it. They didn't know they even could. So look at that. And then the last thing is this isn't necessarily change of control, but what I see at options, believe it or not, I see a lot of options where the option is there's a 5-year lease, and there's 3 5-year options. And what I'm seeing is a party saying, we'll set it to fair market value upon the option, but they don't define how fair market value is determined. Well, that's just a recipe for a renegotiation. And so if you're going to reset the value of a lease, by all means, talk to your client on either side, the landlord or the tenant side. How are we going to set that fair market value? Don't just say it'll be fair, because everyone's different definition of fair is different. So with that, I thank you. I'm going to turn this over to Anna Burnett now to talk about the defenses in commercial leases section. And hopefully, there she is.
Hello, can you hear me?
Well, I can. I'm not sure. I'm not sure everyone is muted, but I can hear you. So go ahead.
Okay, great. Thank you. Get this set up. Okay. Okay, well, thank you, Fred. I appreciate that. Had some technical difficulties. No. Hi. Okay. So with COVID-19 and Gavin Newsom's stay-at-home order have created real challenges for tenants and businesses alike. They are struggling, as you know, with those orders, and many times tenants are now seeking to get out of the leases that they are in. And so one thing that we are hearing is COVID-19 a force majeure event? And or is there a way I can get out of my lease? So I want to point out that this analysis needs to be conducted on a very case-by-case and fact-specific basis. So what is force majeure? Force majeure is a contract provision and may be raised as an affirmative defense that forgives performance or allows for non-performance of one or both parties to a contract. So what we need to be sure is that force majeure must be written into the lease, so or contract in which the party seeks to exert it. So for example, a contract's force majeure provision might allow a construction company to temporarily stop construction of or repairs to a building in the event of a hurricane, riot, or government mandate in connection with a pandemic. So tenants, like I mentioned before, tenants often ask, do I have to pay rent? Most likely the answer is yes. It is more often the case that a tenant's obligation continues and lease payments are neither delayed nor excused under a force majeure event. So, tenants seeking to invoke the force majeure clause of the lease, like I mentioned before, must be written in the lease, have the burden of proving a force majeure event and the resultant outcome. So in the lease, if there is a force majeure clause to begin with, the clause must often state what constitutes a force majeure event. Many of you have likely heard of the terms act of God, riots, warfare. Frequently missing from leases that we see is pandemic or epidemic. And then second, does the clause set out the effect on the parties' rights and obligations if a force majeure event occurs? So for example, if there is an act of God, hurricane, riot, act of war, terrorist strike, what is the resulting event? Will it say rent is delayed, rent is excused, etc. So okay. Thanks, Fred. I'm having some technical difficulties. I apologize. Okay. Okay. So here's an example force majeure clause that we often see in leases. As you can see, it's pretty lengthy, but that's given the screen here. So if either party to the lease is delayed or prevented from performing any obligation under this lease, excluding the payment of rent or security deposit, by reasons of strikes, act of God, shortages of labor or materials, war, terrorist acts, civil disturbances. And then this is the new area that we're starting to see in some leases, where it specifically calls out disease or other illness as determined by the Centers for Disease Control and Prevention. Then each party's performance of such obligation will be excused for a period equal to the duration of the force majeure event, or if longer, the period of delay actually caused by the force majeure event. So what that means is if a force majeure event, such as a global pandemic, that would excuse the performance during that period or for the length of that's actually caused. So right now with the, we need to be clear about what is constituting a force majeure event. Is it COVID-19 itself that is preventing performance of one party, or is it COVID-19 causing a governmental shutdown that is causing a force majeure event? So force majeure is likely not going to be what your client or what a tenant can exercise to get out of paying rent. So alternatives to the force majeure clauses are the common law doctrines of impracticability and frustration of purpose. These two are very different in the sense that impracticability is excuses contractual performance by delayed by an irresistible superhuman cause or the operation of law. So oftentimes impracticability means that performance is nearly impossible, so that performance must attach to the nature of the thing to be done and not to the inability of the obligor to do it. So I have an example I wanted to show you that says landlord and tenant enter into a lease agreement for a term of 10 years. In year 3 of the lease term, a fire partially destroys the premises. Courts have held that in this instance, payment of rent by the tenant was excused under the theory of impracticability. And this is because if a fire burns down your premises and you can no longer operate your business from that premises, the performance is almost impossible. And then this is a couple of different elements that the tenant must prove. So a tenant, to assert the defense of impracticability, has a 5-step burden. You can see there that supervening event made performance impractical. Non-occurrence was a basic assumption on which the contract or entitlement or lease was based, and it resulted without the fault of a tenant. The tenant did not assume the risk, and the tenant did not agree to perform despite that. So oftentimes in leases, though, we do see clauses relating to a partial destruction or a complete destruction. And a good thing to remember is that leases are contracts, and parties can contract around these common law doctrines. So frequently, a frequent lease provision is what happens, and it sets out the rights of the parties in the event of a partial or a total destruction. And you just have to really be paying attention to your leases and analyze them on a, like I said before, fact by fact and case specific basis as to what the different rights of the tenant are under either a partial destruction or a total destruction. So similar to impracticability, frustration of purpose is also a common law doctrine that refers to an unforeseen circumstance that substantially destroys the value of performance to one of the parties. It occurs when performance remains possible, but the fundamental reason of both parties for entering into the contract has been frustrated by an unanticipated supervening circumstance, and the event substantially destroys the value of performance. So an example of this is that landlord and tenant enter into a lease agreement in January 2020, approximately 2 months before the stay-at-home order was issued. Commercial business suffers because its business was deemed non-essential and therefore shut down. Now, question for you, is the defense of frustration of purpose sufficient to avoid payment of rent? Most likely no. Courts have generally hesitated to discharge parties from their contractual obligations based on the general policy that parties should be held to their contractual promises. Now, this is not to say that landlords and tenants cannot enter into alternative arrangements or alternative agreements. In fact, we, as Fred mentioned, encourage tenants and landlords to communicate during these tough times, to try to work out some sort of rent deferral or rent abatement agreements where they can postpone rent to another time. So COVID-19 is not likely going to constitute either a force majeure event, because that requires a contract provision in your lease, nor is it going to constitute nor is it likely to constitute impracticability or frustration of purpose. And when tenants are seeking to utilize these defenses for non-payment of rent, you need to be very clear about what the event is that they're trying to utilize. COVID-19 would suggest that you yourself maybe got it and therefore unable to perform, or more likely a government shutdown is frustrating the purpose of your business. So again, a couple of things to remember when assessing the applicability of the doctrine of commercial frustration. A party hindered by COVID-19 should ask the following questions. What was the main underlying purpose? When did the contracting parties meet or decide to enter into the contract? Was it before or after COVID-19 outbreak was publicized? And can frustration be explained by reasons other than simply the loss of revenue or loss of profit? A tenant's inability to make money because it's shut down is not likely going to be enough of a reason for that tenant to get out of the lease or excuse its performance of payment of rent. All right, so now we're on to commercial purchase agreements. So this is one of the other types of commercial contracts that are important when you're dealing with commercial purchases of land and sales. So California Civil Code Section 1624 requires a written contract for the purchase or sale of land signed by both the buyer and the seller. And this also goes back to the old common law rule of the statute of frauds, so which set forth that land acquisitions must be written. So this agreement is usually called the purchase agreement, or sometimes you maybe have heard it called the purchase and sale agreement. And there are three commonly used forms that I've seen in practice. One is the CAR form, CPA, which was revised in December 2015. This is the commercial property purchase agreement and joint escrow instructions for non-residential purchases. I'm sure most of you are familiar with this form. And then we also have the AIR CRE form. So this is the AIR commercial real estate. And it's similar to the CAR, but it's different in the sense that it's put on by a different it's sponsored by a different organization, and it has a different layout. So it is the standard offer agreement and escrow instructions for purchase of real estate, non-residential. You'll note that both of them have joint escrow instructions in them, but that doesn't mean that those are the only escrow instructions that might come about. As you're familiar with, escrow companies oftentimes have their own set of escrow instructions they provide. And finally, the third form that we see is either an attorney or broker drafted form. So when you're dealing with a written purchase and sale agreement, these are often a lot more edited and really need the advice and review of an attorney. Fred was saying that it's important to have an attorney review your commercial leases to make sure that they are negotiated and meet the needs of your client. Well, the same goes for these types of agreements. They definitely need to meet the needs of your client because not every client has the same goals when they're trying to purchase commercial real estate. So here are some common deal points that we include in these commercial purchase agreements. They detail how money and necessary documents change hands between the buyers and sellers and lay out a timeline for either the deposit of the initial deposit and also then the exchange of documents. In addition, they lay out the timeline that says the buyer has to inspect the seller's documents and property. And these timelines are very, very important to get right and also to stay on top of and track. Oftentimes they are different. You might have a different timeline or deadline for buyer's survey review, buyer's title review, buyer's acceptance of seller's documents. So it's important to make sure that you capture those properly in this written agreement, because once it is signed and delivered to escrow, it holds for the rest of the deal. Your purchase agreement will also contain the representations and warranties the parties make to each other, the covenants the parties agree to perform, and the timeline and procedure for closing the transaction. So once that buyer either approves or waives its contingencies, what happens then? How many days does buyer and seller have until they go to closing? What are the timelines that buyer needs to submit the final purchase price? What is the timeline in which the seller needs to deliver a fully executed grant deed to the escrow holder? So this is important to be captured in your purchase agreement. What are the provisions in case of default? So we'll talk about this in a minute too, but what happens if buyer doesn't approve buyer's contingencies on time? What happens if seller is late in the delivery of materials that buyer needs? What happens if seller doesn't allow buyer onto the property in order to perform its inspection? So these are all things that should be carefully negotiated at the beginning of your purchase agreement and captured therein. And then any other general provisions and miscellaneous issues that the parties want to address. Oftentimes, Fred mentioned that you'll see an AIR form with an addendum. That is also very, very common in these commercial purchase agreements, to have an addendum that sets forth additional items. So even though that those forms are great and they contain a lot of good information, they don't always contain everything that you'd want to see. For example, what happens if a property has hazardous waste, or if there was a previous conflicting use, or tenant, for example, hasn't paid rent in a while. So there's other deal points oftentimes in these commercial deals, because they're somewhat more complex, that they need to be captured in an addendum. Also, electronic signatures are becoming very popular. So many of the pre-printed forms don't always have the electronic signature provisions in them. Now here's some considerations for if you're representing a buyer in a commercial purchase agreement. So these are some provisions a buyer should ask for. One is the receipt of a tenant estoppel certificate prior to closing. I know that sometimes they're not always as common when representing buyers in residential purchases, but in the context of commercial purchases, it's very important to get this estoppel certificate if you're the buyer, because it sets forth certain rights that the buyer can rely on. And that's not so far as to say it's an amendment to a lease, but in a tenant estoppel certificate, you will often see things such as tenant certifies to the buyer that tenant is not in default under the lease, that landlord is not in default under the lease. And then tenant also makes certain certifications to the prospective buyer that about when the lease commenced, and then when the lease will terminate, and then what amount of security deposit, if any, the current landlord has. And these are very important representations, because those certain items, such as security deposit, any prepaid rent, will be prorated through escrow and or transferred to buyer. So buyer wants to make sure that at this point in this stage that they are getting everything correct on a tenant estoppel certificate. And this is particularly true in a retail context, such as if you're representing or if you're purchasing a retail shopping center or a strip mall when there's multi-tenants. So very important to get that tenant estoppel certificate. Also, you want seller's obligation to cooperate and buyer's environmental due diligence, and of course, cause the tenants to cooperate as well. So I mentioned before about hazardous substances. Sometimes you can see by going to GeoTracker, which is a California website, whether or not there are any active environmental cases. And then so that's kind of one good thing you can check in advance. Alternatively, in the commercial context, when one is getting a loan to finance a deal, lenders often require a phase 1, and then if the results of the phase 1 come back indicating the presence of any prior polluting business, let's say, like a gas station or a dry cleaner, a lender is often going to require what's called a phase 2 environmental site assessment. And that is intrusive and requires drilling into a property. And so some disturbance of a tenant, but what you want to make sure when you get in your purchase agreement is that you have seller's obligation to cooperate. So that if you need to do a phase 2, seller can't prevent you from performing a phase 2. And then also seller will do their best to get the tenant to cooperate. Another thing that I see that sometimes people forget to put into a purchase agreement is the right to assign. So you want to make this very clear that buyer has the right to assign the purchase and sale agreement, not necessarily to a third party, but to a buyer affiliate. And this is necessary sometimes in order to accommodate a 1031 exchange, or, for example, buyer wants to not close in its main operating entity, but would perhaps prefer to close the property and hold title in a special purpose entity, which only a single purpose is to hold title to that property. Fourth is to provide meaning remedies for seller's breach. And this is important because a lot of times if a seller breaches a purchase agreement, its only remedy to buyer is that a buyer will receive a return of its initial deposit. Initial deposits vary on commercial deals and oftentimes are tied to the dollar figure of the purchase price. So for example, on a $3 million deal, you might have an initial deposit of $100,000. Therefore, if seller breaches the purchase agreement and buyer does not approve or waive its contingencies, then buyer's sole remedy is a return of its deposit. Now, one thing that's good to do in this instance is to put seller on the hook for any of buyer's due diligence expenses. Let's say, for example, the buyer did do a phase 2 environmental site assessment. Then you're looking at maybe upwards of $20,000 that buyer has spent on due diligence costs for this transaction. And in that instance, you would want to, if seller breaches, you would want to make it a meaningful remedy and have seller compensate buyer for any and all due diligence expenses. And finally, one really good tip for when you're representing a buyer in these commercial purchase agreements is to change either the oftentimes pre-printed language in the forms or just verify that you have an affirmative approval of buyer's contingencies. So instead of buyer, instead of the normal phrase, and I know the AIR form where it says that upon this date, buyer shall be deemed to have approved if no written approval, change that to say that buyer shall be deemed to disapprove, because we want buyer to be in the best position as representing buyer so that if there's no written approval, no written notice from buyer, that it's not an automatic assignment or not an automatic approval. Because once that approval is given, then the initial deposit in most cases usually becomes non-refundable to buyer. And finally, when representing the seller, here's a couple things and tips that is important to remember for the seller side. So seller should insist that estoppels run to the seller's benefit as well to the buyer's. This means that a seller should be able to rely on an estoppel from its tenant as well as a buyer. If seller can rely on estoppel, it makes the likelihood of a post-closing claim from a tenant less likely. Second, seller should use amendments as a means to confirm key facts about a transaction. So for example, oftentimes if buyer needs more time to conduct its due diligence, it will go to the seller and ask seller that it needs maybe an additional 10 days to complete its lease review and review of tenant documents, or buyer needs an additional 20 days to perform a phase 2 environmental site assessment. When buyer makes those requests to seller agrees, seller should include in any amendment to the purchase agreement that confirmation of certain other facts. So if buyer is asking for an additional 20 days to perform an environmental site assessment, seller could insert into that amendment, notwithstanding such extension and non-approval of the environmental contingency, that buyer approves of its title contingency, or buyer approves of its survey contingency, or the tenancy statements. Something to that effect where where seller gets a little something for agreeing to that amendment. And finally, depending on the dollar amount of the transaction, request an additional deposit once buyer approves or waives contingencies. And this is just also something that's fairly common in commercial purchase agreements, that when the buyer approves or waives its contingencies or conditions to closing, that buyer will have to deposit an additional deposit in escrow, and that money is also non-refundable. With that, I have concluded my portion of the presentation.
Hi, everyone. I'm back here. That is our presentation for today. We left a significant amount of time here for questions, so that if people have questions, I know there are a number of people that have been listening here today, and we could certainly talk about these issues for forever to some extent. But we wanted to leave some time open for questions. But before I open that up, I just want to mention, here's our contact information, that if you want to take this offline, or you have additional questions, or you want to work with someone on one of these deals, here's our contact information over at White and Bright, and our email addresses and phone number. So please, connect with us on LinkedIn, give us a call. We're more than happy to talk with you and your clients, so that you guys, so that we can close deals on these and not break them. But with that, I want to open it up for questions for either for Anna or for me, whatever you might have. There's typically a chat on here, and let me go to that as well. And let's see. It looks like a couple of people are asking if we can provide our slides. That's not a problem at all. We can provide our slides certainly to everyone here, and to Shirley, so that she has a copy of them and can mail them out as well. Is there any? See, can you personal message screens? I'm not sure exactly what that is. Are there any other questions anyone has? Don't everyone jump in, but if you do have a question, you can type it in, or please unmute yourself. That's fine too, and ask away. There's someone with their hand up, but I'm not exactly sure how that works. It looks like it's Kevin. Maybe we can't unmute. Shirley, do you have a way to unmute Kevin?
No, everyone's muted. Everyone is muted. They'll just need to put their questions in the chat box.
Oh, okay. Well, there you go, everyone. You have to put it in the chat box. Sorry about that. Because that's why we didn't hear it from everyone. But please put it in the chat box, and we'll see if we can. Okay, so there's a question here. Do you have any recommendation for extra classes for commercial transactions? I think it'd probably have to be a little bit more specific, because commercial transactions can run the gamut. I mean, a land deal of raw land is a much different transaction than a multifamily residential, for instance, or which one of the things we didn't talk about a lot today at all, multifamily residential. But I would narrow it down. If you're looking for a recommendation for additional class, I would narrow it down to what type of practice or what your target is. I know obviously the same people who do raw land in Valley Center are not necessarily doing a 10-unit complex in commercial complex in City Heights, for instance. So I would narrow it down to what your specific area is, because some of this ends up being quite specific. Anna was talking about things like environmental and doing like a phase 1 and phase 2. Well, that really applies for certain types of properties. Other properties, that's a very minor consideration. So it really, I'd say know your practice area, know where your focus is, and look for classes that are there. you know, for instance, the question here is small commercial strip malls. You know, do you have a recommendation for classes there? I don't know any specifics of a class targeted towards that I'm aware of. Anna, are you aware of any classes that are specifically to the small commercial strip mall?
No, I'm not. And Elizabeth, I'm looking at your question right now. And so you are interested in a commercial transaction from start to finish? Is that something that is that what you're asking about? Because I don't know if classes outside of, you could do some reading or internet searching, but maybe that could be a topic we could do another webinar on, a commercial real estate transaction from start to finish, because there's a lot that was not included in this presentation that definitely we can talk about, you know, like starting from the negotiations to negotiating an LOI, and then getting in through, you know, what happens once your LOI is signed, and then all the steps that you need to go through.
And it's actually a small commercial strip mall, now that it's mentioned, that actually is probably a good one to use, because there's such overlap there between the mom and pop aspect of it, of a smaller transaction, but also it's a shopping center, right? And there's things like exclusives, there's things like parking issues. There are things that would come up in a, you know, a much larger center, but are somewhat miniaturized, but you have a lot of the same problems or the same deal points that you want to negotiate that you would if you were, you know, going to the latest development, but, you know, you're working with a center that's maybe from the 70s, and it has a lot of, it sometimes has even more challenges than a newer center would have, because you have these existing uses, you have these operating expense problems, you have these, you know, you have a whole number of, you might have mixed leases, you know, some people are on gross, some people are triple net. It's just, you have, you know, it's somewhat the Wild West with small commercial strip malls. So that actually would be a good of start to finish. Okay, we have a sample, you know, we have a sample start of a transaction, as you were saying, Anna, from start to finish, what that might look like, or where the bombs are on a transaction like that. So
Yeah.
that you can seek to avoid them in your own transactions.
Yeah, and that brings up that multi-tenant situation that does require sometimes a lot of review of the leases. Fred mentioned you could have different kinds. Yeah, you could have different forms. Some entered into different times, different terms, different previous owners want different things. So yeah, that is kind of like the Wild West of all these different tenant issues could come up.
There's another question here. What kinds of due diligence or inspection for buyer to obtain for car repair, gas station, car body shop? Anna, do you want to take that one?
Sure. Yeah, so that is a situation whenever you have anyone that could be performing a potentially hazardous use, that you want to make sure that you do your due diligence to see if there's any violations on record with the city, the county, the state. Water boards is one that, and then the County Department of Environmental Health track violations of those sorts. And then also you would definitely want to talk to an environmental consultant and see what they think about going forward. But normally most environmental consultants are going to want you to do a phase 2 environmental site assessment, and you know, knowing how to rein some of those consultants in, and so that they don't go too overboard and run up costs is important. But definitely you would want to take a look at the lease, see how long they've been there operating, and then definitely make sure you have your environmental ducks in a row, because if you purchase a site that was a car repair, gas station, body shop, maybe a body shop isn't as polluting as one would think as a gas station, because a lot of the times gas stations had underground storage tanks, and one thing we know about underground storage tanks is that they tend to leak. So that's, you know, environmental due diligence is it's a whole other big topic that we could talk about. Also, what constitutes a hazardous material, whether it be asbestos, lead, petroleum chemicals, paint, gas fumes. So just make sure you take a look at existing leases and then how long they've been operating in a certain place. And then also one thing to consider in your due diligence is, what is the future use? Are you taking that use and are you going to continue to operate or lease to a car repair, gas station, or body shop, or flip the use? So that's a whole other issue.
Yeah, that's really important. Is you'll see a lot of new developments as they're developing on land that's, you know, if you look at urban infill, for instance, a lot of the urban infill, it's being built. So, you know, there was existing uses there for 100 years at some point. And at some point along the line, did they have gas tanks there? Was there dry cleaners there? Was there, you know, what was there that, you know, it might not even be those, you know, it could have just been someone who decided to dump, you know, they decided to bury their trash. I mean, you have all sorts of uses that you may not know who was there, you know, over the last 100 years. And so, you know, Anna's right that you really want to engage those consultants if you have someone who's buying and is thinking about some other use than what's there.
Yeah. One other thing I didn't mention that is also really important in any process of due diligence and any kind of purchase and sale transaction is your title review. You definitely want to make sure that you look at chain of title and either have a good title attorney review the preliminary title report that you get from your title company. Because sometimes on title you can see certain things such as environmental liens or any workout agreements or just various gems can be found on title reports. Don't ignore your title.
Okay, so someone asked about this webinar being recorded. Can you email the link to watch it again? I believe, Shirley, if I'm not mistaken, this would be available on the NSDCR's website. Is that correct?
Yes, probably later today or tomorrow. It will be at www.nsdcartv.com, where they can find all recording webinars located.
Great. Great. Well, are there any other questions? I'm just scanning the list here to make sure that we've answered all of them. I think we have. So with that, I think we're done for the, you know, unless there's another question here. I think that's it for today. I thank everyone for joining us today and for listening to us talk about these issues that I know are important to you. And like I said, please feel free to follow up. Our contact information is there. Always like to hear from the brokerage community and the commercial brokerage community. And we'll look forward to talking with you.
Thanks, everyone.
Thank you so much.
Thanks, Fred. Thanks, Anna.
Take care.
Bye.